Hello and welcome to Privacy Corner. I'm Robert Bateman, privacy writer and communicator and various other privacy related things. And this week I am joined by a guest, Avishai Ostrin, who I'm sure you will know if you're on LinkedIn, a very prolific content creator and well-known privacy expert. So on the Privacy Corner each week, we talk through what's happened over the last week or two in this very fast developing and exciting field. And we generally go through a couple of news items and then focus in on one topic in a bit more depth. This week, we're going to be talking about the EU-US data privacy framework, of course, and a bit of an update today on that because the European Data Protection Board has said something about the final version. Some quite useful advice actually for organizations in the EU. So let me introduce Avishai, he works for Privacy Team. And well, why don't you tell us a bit about yourself, Avishai, in case people don't already know?
Thank you very much, Rob, and thanks very much for having me. So I'm Avishai Ostrin, Director of Advisory Services at Privacy Team. Very passionate about the privacy space, advise several clients, mainly in the tech sector, on global data privacy issues, and very excited to chat with you today about some of the ones that have been in the news over the past few days.
That's great. And, Avishai, you're one of those people that when I talk about this stuff to you, I know you really know your stuff. So great to have you on. So look, as I mentioned, we're going to talk about a few things this week and then focus in on the DPF, which is what everyone is talking about, and still lots to discuss about it. So I thought we'd start off by discussing another big privacy story from this week, which comes from Norway. Now, the Norwegian Data Protection Authority has made a pretty bold move this week. It banned, in its own words, Meta from behavioral advertising in Norway, effectively. Now, I think they might have overstated their action here because Meta could still get consent for Facebook and Instagram users in Norway to use their personal data in this way. But the main issue is that Norway has declared that Meta is no longer allowed to rely on legitimate interests, which it has been doing since the spring after the Irish Data Protection Commission, at the behest of the EDPB, told Meta to stop relying on contract. So we've got this kind of whack-a-mole situation with regard to the legal basis for its advertising. And the important thing to bear in mind here is that, as I understand it, this applies to first-party data, as they call it. So this is data that Meta is collecting on its platforms and obviously allowing targeting other companies' ads on that basis. So Avishai, what are your thoughts about this? There's a lot going on in this decision. Any initial thoughts on what Meta should be doing or what they've done wrong, or whether the Norwegian DPA has perhaps overstepped the mark here?
Yeah, it's a really interesting case, Robert, and I think just to add one thing is that it comes off the heels of a decision by the CJEU about the use of behavioral advertising, and I think that what my main takeaway from this decision. And another thing, by the way, to mention is there was an interesting invoking here of a lesser used article of the GDPR, where the Norwegian, normally speaking, we have the one-stop shop mechanism where they would have to go to the supervisory authority, which is the Irish DPC, obviously. But in this case, the Norwegian authority decided they were going to surpass that mechanism, which they can do if it's an emergent or an instance in which time is of the essence, and they can only put in.
Oh, Avishai, you've gone onto mute.
Oh, sorry about that.
Carry on.
But I think that all the technicalities aside, the interesting thing here, and the thing that sort of is interesting for me when I advise companies on sort of global data protection issues, is to look at it stresses the importance of looking at all of the guidance that's being put out from all of the supervisory authorities. We're so used to looking at GDPR as one harmonized sort of system, where in fact so much is left up to the interpretation and the guidance of the supervisory authorities. Here, we certainly have a very bold step by the Norwegians. We'll see if it holds up. I fully expect Meta to challenge this decision. So it's definitely not the end of the story here. So it's worth paying attention here. But I think what it stresses for both advisors in this space and for companies is keep your eye out for supervisory authority guidelines and trends, because you have to stay up to date on the various different enforcement actions and trends in order to properly advise your clients in a global setting.
Yes, there's two things I will add to that exact point. You've reminded me that, firstly, Meta was only relying on contracts because it received advice from the Irish regulator when the GDPR kicked in that this would be an appropriate legal basis. So that, I think, underpins your point that there's a lot of divergence within the union itself as to how to interpret the GDPR. Of course, we've got the consistency mechanism that should iron those inconsistencies out. But here we have a DPA that has used another provision to, I don't want to say circumvent that process, but has found another way to impose its own interpretation onto Meta. And secondly, so Meta gave this big opt-out form to users when it switched over to legitimate interests. I filled it in, and they rejected my objection because I'm in the UK, which has the same GDPR, but they are not applying the rules in the same way. So I think that also underlines your point that you can have the same law interpreted very differently by different authorities, and that really is important to be aware of. Quite hard, makes things quite unpredictable, I think, doesn't it, for these companies operating across borders. So that's a really big deal. And of course, you are right to raise the CJEU decision from last week that obviously emboldened the Norwegians to act in this urgent procedure. So before we get on to the DPF, there's also, from the other side of the pond, as we call it in the UK, the CCPA. So the California Attorney General, and I think I made a mistake about this on LinkedIn by saying this was done by the new regulator there, the Privacy Protection Agency. But the Attorney General has written to a bunch of companies asking how they comply with quite a, not an obscure, but an area of CCPA compliance that I expect many businesses have neglected, which is the employer-employee relationship. So under the CCPA, unlike many other laws, employees are considered consumers. And I've always wondered if that was simply an oversight when they drafted this law, because none of the others apply in that context. But what do you think, Avishai? Do you share my suspicion that businesses might not have considered this part of compliance as they rush to comply with the new CPRA, for example, and other provisions in the CCPA?
Yeah, I can tell you, from personal experience that it's something that has come as a surprise for many organizations, and it's something that I and others have raised flags about when CCPA and CPRA came into force in terms of the applicability to employee data. And it's one of those areas where, for practitioners and business people used to operating in GDPR in the European context, it's not that surprising to say, oh, by the way, you also have HR data, to which the GDPR or the UK GDPR as applies, applies to that data as well. Whereas in the US, you mentioned it just a moment ago, none of the other privacy regulations, the state privacy regulations, apply to employee data. And so this, I think, did come as quite a surprise for many of the businesses. And, if you ask me what my view is on this, I think it's a very good thing. I think that California has been the trailblazer when it comes to data privacy regulation across the U.S. and has really nudged the U.S. in a positive direction when it comes to privacy regulation. And maybe this is something that we'll see other states following suit. I don't know, but certainly it's something that companies need to be aware of and need to take seriously. And another thing, by the way, just about the style of this, I think we've seen several announcements, both from the California Attorney General as well as from the FTC in the US, about sweeps. And it seems like that's something that they're quite accustomed to, which is very different to the enforcement style, I would say, in the Union and in the UK. And so that's, also something interesting to note, is that when they do, there was, I believe the previous one was about children's data on online application apps, mobile apps. That was the previous sweep that they did. So they take a topic and they go deep into that. Sorry, not deep. They go broad to many, many companies. And that's something to bear in mind in terms of looking at where the regulator is putting their focus and making sure you have all your T's crossed and I's dotted in that area, because it's likely that then you may have this regulatory sweep coming in the next cycle.
That's a really good point. And you do occasionally get these sort of sweep style things. I think maybe I remember one from France on cookies, but generally you're right. I think the European regulators are more reactive to individual complaints, whereas in the US, the best example for me is the FTC. We talked about this a lot on Privacy Corner. We had three health-related privacy cases in a row, then 3 kids-related privacy cases in a row. So it was a very clear sort of pattern. And the FTC said, these are the areas we're going to be focusing on. And then they did them bam, 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 3 in a row in each topic. Right. So that's a really good point, I think. You can see these things coming if you're looking closely enough and if you're being advised by the right people, I suppose. The other thing, before we get onto the DPF, about this one, Avishai. Now, when you think of data breaches, you might think of sort of sophisticated cyber attacks, ransomware, and those sorts of activities. But there's another example in the news this week whereby apparently millions of confidential military intelligence documents have been leaked via another type of data breach. Do you want to tell us a bit about what happened here, Avishai?
Yeah, so this was one of those ones where you couldn't make it up if you tried, which was there was a mail operator who was, and this I think was a Financial Times, an FT article that uncovered that there were, I don't remember the number, but highly sensitive military intelligence documents were leaked to someone who wasn't in the military, simply because they made a typo in the email address, addressing it to the recipient, and then at the end ending in .ml as opposed to .mil, which is short for military and what they had intended to send it to. And so, yeah, the reason that I love this, not love it that it happened, but I like that we can use it because I really think that it exemplifies the fact that, just as you say, we imagine data breaches to be these crazy, hackers anonymous sitting in their dungeons and stealing all of our data and then encrypting it and asking for ransom. But in fact, human error is responsible for a lot of this stuff. And the way to make sure that this stuff doesn't happen is educate your team, make sure that people understand the importance of privacy protection, make sure that people understand and are aware and will check their work twice and 3 times and 4 times before they send something out, especially something external. And so it's that awareness and that training that will really prevent these types of situations from happening. But the fact that it happened to the military is just goes to show that no one is immune from this type of activity.
Yeah, that's right. So I think this has been happening for quite some time, and as you say, it's the domain, the top level domain. I'm not very good with internet protocol stuff. Top level domain, I think, that is .mil, and people have been typing .ml, which sends it to some inbox in Mali, because that is the associated domain name with that country. So that's very unfortunate, and I think it's just one of those things that you wouldn't necessarily think about unless you were thinking very systematically about the risks of data breaches. So let's move on now to the data privacy framework. So as anyone watching a live stream called The Privacy Corner will know, last week the European Commission adopted an adequacy decision in respect of the United States. And the new scheme, the data privacy, EU-US data privacy framework, or the DPF, will be a replacement for the ill-fated predecessors, Safe Harbor and Privacy Shield. So businesses in the US can sign up and self-certify each year, and they will, EEA-based organizations will be able to send personal data to those companies without doing very arduous risk assessments, putting in standard contractual clauses, and so on. So
supplementary measures.
Yeah, all the stuff. And, as we know, possibly not doing it at all, because those measures will not appropriately shield the personal data from the NSA or whoever else requests it in the US. So look, the news here has been explored in depth by many people, but we can give our own perspectives on it. I think I'd like to ask, first of all, Avishai, would you, or indeed will you, be advising US businesses to sign up to this, or what will you say if they ask whether it's worth doing?
So it's an excellent question, and indeed people have opined on this. I think from at least my LinkedIn feed is exploding with advice and analysis on this stuff. My answer is very simple. There's not much downside. I think the bigger question, so the answer is yes. I would certainly advise US businesses to sign up for it. I think it has value, even if, as we saw with Privacy Shield, by the way, even if it's not a valuable tool for an Article 46 international transfer mechanism, it still does hold value for US businesses to be able to certify that they do have appropriate data privacy measures and a data privacy program in place. So I certainly think that even just from that perspective, it's worth signing up for it. in terms of an international transfer mechanism, I think that remains to be seen. But we're probably a few years away from seeing whether this, obviously Max Schrems has already said that he was going to challenge it, but we don't know what the outcome of that case is going to be. And we don't know how long that's going to take. So at least for the next, couple of years until the case makes its way all the way up, we can enjoy some stability in the same way that we did with the Privacy Shield. And as you say, less arduous contractual terms. However, what I would advise is not completely chucking the SCCs into the bin just yet, because we've been here before, and as the saying goes, fool me once, shame on you; fool me twice, shame on me. So it's now the third time, and so I think we've learned from this that we should take it with a grain of salt. So to summarize, my advice would be definitely sign up for it, but keep a plan B ready in case the invalidation does inevitably come through. And we all remember the pain of not being afforded, I think it was July 2021, of not being afforded a grace period when that CJEU ruling in Schrems number 2 came down. So
2020,
yeah.
I think it was. You're right. It was no notice. Yeah, that's right. It was immediate, wasn't it? Because the first in Schrems 1, they gave 3 months, and then
Correct.
The second time it was just cut. What's it? By the way, it's fool me once, shame on you; fool me twice, shame on me. Is there a fool me 3 times? Is it shame on both of us? I remember a George Bush clip where he fudged that aphorism. That was very funny. So look, yeah, I agree. I mean, if I were a US business, I'd probably go for it, because it's one of those things, I think, like having a coherent and functional privacy notice, that it just shows you're thinking about this stuff. If you're a smaller business, especially, or more importantly, if you're a larger business, it's just a kind of seal, an initial, obviously it doesn't necessarily mean anything, but it is better than not having it, I think. When I interviewed Schrems about this in 21, and even then he had a plan for challenging it. And I think that there are a lot of people that are merely asserting that it will fail without providing much analysis as to the strengths and weaknesses of the underlying legal reforms that have been put in place. I would not want to bet against Schrems based on past experience. He tends to win in this and other areas. So you're right. I mean, people need a backup plan. I don't know if there is a decent one, to be honest, but you definitely need something else in place. So what do you think are the chances?
But if you had to bet, what would your money be on?
I'm very bad at making predictions. I think the problem, some of their arguments are better than others. I don't know if I'm missing something, but the fact that it was implemented via executive order, I don't think that's necessarily as big a weakness as they suggest. I always compare it to the parliamentary process in the UK, whereby the government can kind of do what it wants if it's got a decent majority. And if another government comes in, they can reverse it within 5 minutes. So I think that the executive order issue isn't necessarily that big a problem. It's the Data Protection Review Court. I mean, they've called it a court, but whether the CGAU thinks it's a court is another matter. I think that will again be the Achilles heel. What would you do? How much would you put on it either way?
I honestly, I think that there are many people who understand the details of this much better than I do. So I don't want to pretend to be an expert on these types of things. From my sort of reading of it, I agree with you. I think that significant change has been made and significant progress has been made, and so I'm hesitant to be as blasé as everyone else has been with just completely, you know, tossing the whole thing out.
Yeah.
Even before it was adopted. But that being said, I do think that it's evident that a lot of the decisions around adequacy, in the United States have been, within the European Commission have potentially sort of had more of a political influence on them, and then when they've come and been challenged in the legal sphere, they didn't necessarily hold up. And so that's
Yeah, I
where
think that's a good point.
that's where I would say is the understanding how much of the legal framework of this is actually solid versus just the political elements of it. Yeah.
I think that's a good point. There's clearly a lot of different forces in the EU pushing in different directions, and the Commission has always been very keen.
As we've seen from the note, from the EDPB note. Yeah.
So let's have a look at that, because that's today news. We've only got a couple of minutes, unfortunately. They always go so quickly. So is there any takeaways from you on what the EDPB has said today? They've made an information note. I'm not sure I've seen a note from them before. It's normally a...
No, it's... Oh yeah, a note from the EDPB. Yeah, it's from the 10th, I think. From the day that the
of course. Oh no, that's the date of the decision itself.
Yeah.
So I think this was today or yesterday. Any takeaways from that EDPB? What they're saying about it from you, Avishai? Is there anything? There's something here about the other measures other than the adequacy decision. Is there any impact on standard contractual clauses, for example?
So I think this is a question that still remains to be seen as to whether there was a question raised, I think it was by Phil Lee on LinkedIn. There was a question raised about whether if the protections that were granted by the executive order apply regardless of the mechanism that's used to being transferred, then would that mean would that alleviate the requirement to have supplementary measures if you're using SCCs? Meaning, would it apply for any transfer mechanism you were using, whether it was SCCs or derogation or whatever? And I think that's a question that still remains unanswered. However, there is a little hint in the note by the EDPB that confirms that it applies. So they said, the EDPB said, in this respect, the EDPB underlines that all safeguards that have been put in place by the US government in the area of national security apply to all data transferred to the US regardless of the transfer tool used. So that is potentially a very helpful clarification for those who aren't going to be signing up, or either don't have the ability to, or won't be, to be able to rely on that statement. Although we'll see. I don't know. You had some thoughts about the note when we were talking before.
Yeah, so I think you've picked out probably the most significant bit there, where the EDPB says, they're only referencing what the Commission has said, but they at least endorsed that by the look of it, that regardless of whether you're transferring personal data under another tool or transferring it to someone who's actually signed up to the DPF, those underlying legal reforms will apply with respect to the data that the company's importing. So I think the takeaway is, if you're doing your transfer impact assessment and deciding whether you can do a transfer, don't use the old law to make that assessment. Take into account the reforms that have been adopted under the executive order that
Exactly.
that implements the DPF. So that is
Exactly.
new rights to redress, which will apply regardless of whether the data subject is their data is transferred under the DPF or not, and also some of the restrictions on intelligence services activity. Now, they're good enough for the Commission, so you could say in your TIA, the Commission thinks this is good, so it looks good to me. Of course, we know the Commission's word is not to be taken at face value, but that's certainly going to make TIAs a bit easier, I think, because you're not working with the old law, you're working with this new reformed US legal framework. Whether or not you think it's meaningful reforms, the Commission does. So bear that in mind, I guess.
Yeah, and maybe just one final note. I know that we're over time, but just one final note for UK businesses, because this is an interesting situation that has been sort of created, because obviously those who've signed up to Privacy Shield are and they're remain certified in good standing will automatically need to recertify, but will automatically transfer into the DPF. And the UK extension will also apply to that, but only when the UK itself adopts the UK adequacy decision. I can't remember. It's a bridge, or is it a? I can't remember what.
We're calling it the data bridge. Yeah,
the data bridge.
That's right. So I think that the UK extension is already available to US businesses, but as you say, the Secretary of State for whatever they are calling that department now, business and something, has to adopt an adequacy decision like the Commission. Now, I've been told off the record by an anonymous source that this should happen in October, which is quite a long time, actually. There is, I'd say, a less than 0.1% chance that the UK says that this is not good enough for us. I mean, they are going to adopt an adequacy decision, but UK businesses still have to wait under the law because it's not there yet. So that's a really good point, Abhishek. I'm always thinking about the UK situation, of course, which is very different for data transfers than it is in the EU, given the ICO's interpretation of Schrems 2. Look, it's brilliant talking to you, Abhishek. I was going to do this by myself. It's been so much better to have you to talk this through with. Excellent guests. And as I say, strongly recommend, if you're not already, for whatever reason, signed up to connected or following Abhishek on LinkedIn, please do, because he's got some really great insights. And thank you as well to Privado, of course, Privado AI for hosting this session every fortnight with me. They are a really interesting company doing some very interesting things, trying to bridge the privacy and engineering gap, which is really so important, looking at what's happening in your code, what can be done to stop any data sharing that should not be happening. Very important in the current climate, with all the attention on pixels and APIs and such as well. So thanks again, Avishai, for joining me, and thanks again
for having
to
me, Robert. It's great. Thanks to
great.
Privado.
See you around. Thanks again.
All right, cheers.